matter of Vernacare Limited and Moulded Fibre Products Limited.
Yes, Mr. Arnold.
My lady, my lords, I'm here for the appellant, defendant, Moulded Fibre Products Limited. My learned friends, Mr. Hicks and Mr. Muir-Wood, appear for the respondent patentee, Vernacare. I trust the court has had an opportunity to read the judgment under appeal.
Yes, thank you, Mr. Hicks. We've had an opportunity of reading the judgment on appeal, reading the skeleton arguments, and I think all of us have dipped into the relevant authorities.
I'm grateful there are not too many of those. So, as I'm sure you will have appreciated, the case is all about products moulded from paper pulp. The classic example is an egg box, but you may be familiar with others, particularly pulp products that are beginning to replace single-use plastic. So an example is food containers, and that's an example this case touches on. Packaging inserts are another. If you've bought a television recently, you might have found that it was held in the box by moulded pulp inserts rather than polystyrene. So this is a growing market, and one in which the parties are competitors. And this case is focused on one particular niche in which moulded pulp products have proven successful and in which the parties compete, and that is hospitals. The NHS gets through a lot of single-use moulded pulp products because their use saves on washing and sanitation. And among those articles are bowls that nurses can fill with soapy water, used to wash part or all of a patient, and then dispose of. And this trial concerned the infringement and validity of two Vernacare patents asserted against my client's version of this bowl. Both patents claim an article that is defined as a washbowl, one of a particular shape, and the other moulded from a pulp formulation that includes a fluorocarbon that makes the finished article resistant to soapy water. The trial was heard by Mr. Nicholas Caddick QC, sitting as a Deputy Judge of the High Court. He found no infringement of the shape patent. Vernacare don't appeal that outcome, so we don't need to say anything more about it. The sole issue on the formulation patent or the composition patent was validity. The judge found the patent valid and therefore infringed, and that is the subject of my appeal. The central question then and now is the meaning of the term washbowl, and specifically what type of container this term covers. And subject to the court, I propose to take the topics broadly in the order in which they appear in my skeleton argument. So technical background, skilled person and common general knowledge, prior art, which is a Japanese saite known as Shimooka, and then the patent. And having done that, I will explain what I say about the meaning of the term washbowl and the consequences of that for the validity of the patent. Then I will turn to the judge's analysis and endeavour to explain when I say he went wrong, by reference to my grounds of appeal. And finally, I'll say a few words in answer to the points raised by my learned friends in their skeleton argument. And if I am moving too slowly at any point, traversing ground that you already feel well familiar, feel free to move me on.
You have kind of very detailed lengthy skeleton argument, which we have got to grips with. So
I'm grateful for that. There's a couple of points that really what I intend to do is go through and pick up points that I want to emphasise in my oral submissions rather than to grind through it all comprehensively.
Of course, thank you very much.
So technical background, it's not a technically complex field. The basics are described at paragraphs 14 to 18 of the judgment, and you will recall those. So these explain the basic process of moulding an article from pulp. They describe the use of process additives. They describe the use of functional additives. And there's a brief description of sizing, which is functional additives whose purpose is to give the finished article resistance to liquid, penetration by liquids. Traditionally, water. So that's what the judge describes in 17. So those are the basics, and you don't need any more than that to understand the issues in the case. But one point that doesn't emerge from paragraph 15, but was covered in the evidence, is the importance of biocides in the process, because the water that is extracted from the pulp at the moulding stage is recovered and sent back to the pulper. Otherwise, the process would be grossly wasteful of water because the pulp is very dilute as it goes into the moulder. So the process involves a circuit of water, and the combination of recycled cardboard and recycled water creates very favourable conditions for microbes. And unless their growth is suppressed, the system starts to produce microbial slime that will actually shut down production. And Vernacare's expert, Dr. Kelly, gave very graphic evidence about this at the trial. So that's what the judge is talking about when he mentions microbial growth in the pulp stock. This isn't a nice-to-have feature. It's not possible to run a moulded pulp line without periodically dosing the water with a biocide. And I will come back to that briefly when considering Shimooka and the claims. The skilled person and the common general knowledge. The judge dealt with the skilled addressee of the patents at paragraphs 20 to 28, and I can just summarise, I hope, where we came out. There was a dispute at trial as to whether the skilled addressee of this patent was a team that included a specialist in paper pulp additives. We argued that it would, essentially because the patent leaves a lot of detail to the skilled addressee, but the judge disagreed, and we accept that it was open for him to do so on the evidence, so we don't challenge that aspect of his judgment. So the net result is that the skilled person in this case is a moulding specialist rather than a deviser of pulp formulations. And I've quoted at paragraph 12 of my skeleton the description of that person that was adopted by the judge. And I would ask you to just remind yourself of that description. It may be convenient to take it from my skeleton argument. So 2 points I'd like to pick up. First, Dr. Kelly mentions in this passage maceratable pulp products. And what he means there is pulp products that are sold into hospitals, because those aren't actually thrown in the bin, but they're macerated on site and fed into sewage. And that's because hospitals use a lot of single pulp bedpans and the like. So that's what he means by maceratable. And the point to note is that Dr. Kelly fairly accepted that the skilled person was not confined to the maceratable, i.e. medical field, but was a generalist. So put simply, they'd be interested in making any kind of pulp article. The second point I want to emphasise is paragraph 15 of the quote, particularly the first sentence. The skilled person is primarily focused on moulding techniques to achieve particular shapes. So the skilled person is a moulding expert, and what they're expert in is achieving particular shapes. And the evidence was that a range of shapes already formed part of that person's common general knowledge. I would like to show you a passage of the evidence of Vernacare's other expert, Mr. Waller, and that's bundle B, tab 24, bundle page 434. And for context, and I'm going to direct you to paragraph 20, but for context, the way that Mr. Waller went through, dealt with his evidence was to address my pleading of the common general knowledge, because we're in the Intellectual Property Enterprise Court, so I set out various propositions of common general knowledge, and he's responding here to those, and he says, I agree that containers, including bowls of various shapes and sizes, manufactured from mouldable paper pulp compositions comprising an aqueous suspension of a base material comprising paper particles, were CGK. So that's what I wanted to show you there. So bowls of various shapes and sizes form part of the skilled person's CGK. That was on Vernacare's own evidence. So that's all I wanted to say about the skilled person and the common general knowledge at this stage. What I propose to do now is move on to Shimooka, and the translation of this document is at bundle B, tab 21.
Sorry, tab 21.
21. And it is worth starting with the extract because that touches on two relevant points or two relevant themes. So can I ask you to read the first paragraph of that. And the first point I want to pick up is that this passage and the rest of the document uses the term sheet forming rather than moulding. And understandably, that seemed to cause a little confusion at trial. And indeed, in Dr. Kelly's written evidence, the judge records this, he disputed that it disclosed a moulding process at all. But if you look across at the little diagram on the same page, you will see that it clearly does. So this is a schematic cross-section of moulding apparatus. The feed solution F comes in at the top, there's the big arrow. This is expressly described as pulp. And then this passes through a screen comprised of a carrier net 13 on a supporter 12. So I think the carrier net is essentially a fine mesh that is then supported by the supporter 12, both of which are porous. And as the pulp passes through, the solid component S gathers on the screen, and you can see that the screen and the carrier net are in a three-dimensional shape, and the solid component S in the feed solution gathers on the screen in that shape. The liquid component L comes out at the bottom, and the solid component can be dried and ejected as a container.
So is this a translation issue? I mean, obviously this has been translated from Japanese.
We didn't get into whether it was a translation issue, and certainly the translation wasn't challenged for the purposes of, but what I was going to come on to say is that there are times this document clearly uses language in a somewhat imprecise way, or perhaps a rather inapt way, but it's something that the skilled person can understand by looking at the entire context of the document. That's really the only point.
Yeah, we have to take the translations that's before us.
Exactly so. So it clearly is a 3D moulding process, and Dr. Kelly eventually accepted that in cross-examination. The second thing I'd like to highlight in this abstract are the very first words. It's to provide a short-time use food container in a variety of shapes. And so plainly, the simple food container A that we are shown here, and if you flip on to the last page in the tab, you will see that there is a second figure in this document. These are the only two. You see the little schematic we just looked at. But you also see a simple food container, which appears to be the container that's being made in the cross-section, so to speak. But it's quite clear, as from the abstract and from the rest of the document that I will show you, that this simple food container that you see in that document is just one exemplary shape. What this document is telling you is you can use this technique to make a variety of shapes. And if that weren't clear enough, that is made quite plain by the last sentence of paragraph 26 of Shimooka, which refers to this simple food container. And it's just the last sentence of paragraph 26. As the container is manufactured by sheet forming, which in context means moulding, it is possible to provide a simple food container A with a wide variety of shapes. So one can read that as showing that what you see in the figure is intended to exemplify not just the shape you see there, but a wide variety of shapes. It's given as a single example.
One of the things one sees as suggested as being conventional is top of page 409 of the bundle in the right-hand column is tableware.
Tableware, exactly.
Is that? I mean, is it your case that one of the wide variety of shapes that you might wish to produce is an item of tableware as opposed to a food container, which might suggest a sort of Tupperware box?
My lord, yes, in the sense that I think that gives helps you to understand what the document means by food container. So it's not a container necessarily merely for transporting food, but it's a container for holding food that can also be eaten from. And yes, you get that from tableware. So that very much helps one to understand the range of shapes that the author of this document is contemplating and is recommending that the skilled addressee turn their minds to.
And presumably you say tableware would encompass a bowl.
Exactly so. And I will come on to that probably too slowly for your liking, but as I say, do feel free to move me on. If we turn on to the description, the ability of the method taught to produce a variety of shapes is further emphasised, and I'd like to just look quickly at paragraph 1 because there seems to be a dispute on the construction of this. Paragraph 1, the present invention relates mainly to a sheet-made container, i.e. moulded, made from raw material mostly consisting of pulp, and in particular to a short-time use tray-shaped or cup-shaped food container. And I think my learned friend says you should read that as cup-sized. But I say, in the context of this document, particularly given the rather imprecise use of English words, or perhaps unfamiliar use of English words, I say that this is sensibly read as describing food containers that are both shallow-sided, tray-shaped, and deep-sided, cup-shaped. And it's not about the size of a cup. Fundamentally, I say it doesn't make much sense to consider a food container that is merely the size of a cup. It's not big enough to hold a portion of food. So fundamentally, I say in substance, this is actually describing an article that we would describe as a bowl, as a matter of disclosure. But I'll come back to that point and seek to make it good once we've briefly been through the rest of the disclosure. The real essence of this document is then paragraphs 2 to 4. And you will have reviewed this, but I hope, again, I can summarise to save time. I say these paragraphs make 4 basic points. First, single-use containers are typically made of plastic. Second, it would be environmentally preferable to use paper. Third, the range of container shapes that can be pressed from coated paper or card, that is to say, paper pulp products that's moulded in a flat sheet, can be pressed from coated paper or card is restricted, so you can think of the classic scalloped picnic plate, for example. But that restriction on shape largely disappears if one can mould the containers from wet pulp at the outset. Fourth, moulded pulp products are unable to resist the combination of oil and water. They go soggy. Merely sizing for water repellents is not enough to handle the oil component of the contents. And of course, what Shimooka goes on to disclose is a solution to that problem, the addition of a fluorocarbon to the pulp composition to stop the finished article going soggy when exposed to oil and water. The specific embodiments of Shimooka's invention are then described at 17 to 24. 17 to 19 describe the basic pulp moulding process that we just looked at. I don't need to bother you with that. And then it gives 5 options for applying the fluorocarbon at paragraphs 20 to 24. Some of those involve a dipping or a spraying coating process, but the 2 that I want to focus on, and we can just do the headings, are 20 and 22. And you see 20, the title, Roman 1, fluororesin mixed into the feed solution, and 22, little Roman 3, mixing of fluororesin and liquid hydrocarbon in the food, in the feed solution. So these are plainly both the wet end addition of fluorocarbon into the pulp mix, and 22, this is combined with a hydrocarbon essentially for reinforcements, additional repellents to liquid. And the effects produced by these additives is described from 26 onwards, and paragraph 26 explains that the simple container A of the present invention has the aforementioned constitutions, that's what it's made from, and if we flip on, it goes on to say the surface of the sheet form container has excellent water and oil repellents. It can hold foods containing water and oil, and unless it is used for a long time, it will not lose its shape. No water or oil will seep through, making it ideal as a short-term use container for picnic and parties, etc. And for the reasons canvas, that would include tableware, we say. So in summary, the fluorocarbon gives the moulded article excellent resistance to oil and water, and the moulding process makes it possible to produce food containers in a wide variety of shapes. So essentially what Shimooka is teaching is the best of both worlds. An environmentally friendly single-use food container that can be made in the same wide variety of shapes that plastic containers can be. So standing back, how would the skilled person respond to Shimooka? And the first point I make is you will recall the skilled person is a generalist. They're interested in making any kind of moulded pulp article, and they specialise in moulding things rather than pulp compositions. So what they get from Shimooka is a new pulp composition that enables them to mould a whole new category of articles, food containers that can handle any kind of food. So not merely an egg box or a berry pipe that you wouldn't want to get wet, but a container that is suitable for a far wider range of application. And so that is plainly a disclosure of technical interest to the skilled person, and I don't believe that it is controversial that they would take it forward with a view to realising those benefits. How then would the skilled person implement the teaching of Shimooka? The key point here is that Shimooka is focused on teaching the novel pulp composition and its utility for food containers, but it leaves the variety of shapes to be moulded from that composition to the skilled person. So this is not surprising, as the judge found, and on Vernacare's own evidence, the skilled person is a specialist in moulding shapes, and they already know how to mould containers in a range of shapes. So Shimooka including a list of shapes wouldn't teach them anything that they didn't already know. I've shown you what Mr. Wallace said about that. If you want to see what Dr. Kelly said about it, I don't think I need to turn it up. But for your note, Bundle A, Tab 5, mini script, page 133, lines 11 to 18, Dr. Kelly accepted that what Shimooka was giving the skilled person was a wider range of design options, was what he called them. He volunteered that term.
Right, could you give me that page number again, please?
Yes, Bundle A, Tab 5,
Yeah.
mini script, page 133,
Yeah. Thank you.
lines 11 to 18. So he described the range of shapes made possible. Sorry, tab 6. I meant tab 6. That's the transcript tab. Apologies, that's a bad reference. So in my submission, the skilled person would do as directed by Shimooka and produce food containers, including tableware, in a wide variety of shapes suitable for different types and amounts of food. That is what the document is telling them to do. In my submission, that plainly includes bowls of various shapes and sizes, because such containers were already common general knowledge and are plainly suitable for holding food. We're all used to eating and serving ourselves from bowls. And as I mentioned, I do say that the skilled person would actually understand paragraph 1 to be describing what we would call a bowl as a matter of disclosure when it's properly understood in context. That is what I say cup-shaped is directed to. But even if I'm wrong about that as a matter of disclosure, I say plainly bowls are an obvious implementation of the teaching of this document. So that is what I say the skilled person would do with Shimooka and why. 2 final points. First, it was common ground at the trial that the moulded pulp containers made using the composition taught in Shimooka would not only be resistant to water and oil, but it would be detergent resistant. The judge records that at paragraph 121 of the judgment. So if you follow the teaching of Shimooka, you inevitably end up with a detergent resistant container. That was Dr. Kelly's evidence. Secondly, Shimooka does not expressly disclose the use of biocide. And as I'm sure you have picked up, a biocide is a feature of the pulp composition recited in Claim 1 of the patent. And for that reason, my learned friend is right when he says in the first paragraph of his skeleton argument that there was no novelty attack. He's right about that, and that was my mistake. The biocide feature was a feature added by Vernacare during prosecution to avoid anticipation by Shimooka. That's how they got the patent through. And if you're interested, you can see the examiner's report at tab 33 of Bundle B. But rightly, that feature is no longer relied upon as conferring inventive step. So in essence, it doesn't make a great deal of difference, I say. So with that account of Shimooka, I propose to turn to the patent, and that's at Bundle A, tab 8. Page 1 sets out the problem that the patentee sets out to solve, namely the tendency of moulded pulp bowls to go soggy when they are used to hold soapy water. And I'd like to make 2 points about this passage without reading it out. First, it uses the term washbowl, as does the rest of the pattern, without any attempt to define what that term means, either in terms of functionality or size or shape. That is left to the reader. And with that in mind, I just want to pick up on the passage on this page that describes the patentee's experience with earlier moulded pulp washbowls. At trial, the judge received evidence about Vernacare's earlier attempts at a pulp washbowl from a nurse called by Vernacare, called Ms. Turner Gardner. And I've quoted her evidence on the point at paragraph 40 of my skeleton, and it may be convenient to just go there rather than flicking around in the bundle. So if you could just read the quote under paragraph 40. So just a couple of points to note. First, in paragraph 93 of the judgment, the judge describes this bowl as a general purpose bowl. So if you want to turn up 93 of the judgment, you can see that. So he's talking about Ms. Turner Gardner's evidence about midway, a little bit below halfway through the paragraph. Ms. Turner Gardner's evidence was that on occasion, one of Vernacare's general purpose bowls might be used to wash a patient's hands and face. That was what the judge recalled of Ms. Turner Gardner's evidence, but as you can see from this evidence, which was her evidence in chief, it wasn't a general purpose bowl, it was a bowl that Vernacare marketed specifically as a wash bowl. And they gave it the name for reasons nobody could explain, the LA wash bowl. And secondly, this wash bowl was the size of a cereal bowl, so too big for a full bed bath, but you could use it to wash a patient's hands and face. So I say this is relevant because whatever limits on size might be implied by the term wash bowl, we know that a bowl the size of a cereal bowl was marketed by Vernacare as a wash bowl before they filed the patent, and it was used as a wash bowl by nurses. And we're not aware of that bowl having any special features that would distinguish it from any other type of bowl. That's a point I ask you to bear in mind when we come on to the obviousness case and the construction of the term wash bowl. Thirdly, page 1 of the patent says it's not possible to make moulded pulp receptacles likely to come into contact with soap, but on Ms. Turner Gardner's evidence that appears a bit of an overstatement, because on Vernacare's own evidence you just had to use them quickly. Coming back to the patent, one more point to pick up in the description is the patentee's slightly odd use of the terms binding agent and sizing agent. This begins in the consistory clause.
Well, the judge said it didn't take us anywhere in the end.
It didn't take us anywhere, so I'll move on.
Are you taking a point on that?
It's purely so that we don't get distracted by that term. Or what it
I
means
don't
when
think
we
any
come
of
to
us
it.
are distracted by that.
Then I can move on. So the next point I wanted to pick up is the next point I wanted to pick up in the patent is the description of the fluorocarbon on page 4, bottom of page 3 over to page 4, and that's internal page 3 and 4. And internal page 4, you see it says, it has been found that an amount from 10 ml to 200 ml of the detergent resisting binding agent per kilogram of dry base material is effective to provide the desired properties of resistance to soap and detergent. And if you look down towards the middle of the page, you see at about line 12 a fluorocarbon, preferably a fluorocarbon resin emulsion such as Mystylene D2404, and at line 17, when formulating the composition, the detergent resisting binding agent may advantageously be in the form of resin, emulsion, and or resin emulsion. So the fluorocarbon is not in and of itself a liquid, Rather, it is delivered by way of a liquid carrier that contains the active ingredient. So if we go back to the dosing ranges, the point I will come to on my ground 3 is that these doses are stated in units of liquid carrier, millilitres per mass of pulp. They say nothing about how much of the active ingredient must be present in that liquid carrier. The specification then goes on to describe the biocide additive towards the bottom of page 4 and over onto page 5. That's an entirely standard additive that we've seen. And finally, in the description, we get a full pulp composition recipe. And the judge pointed out there were some oddities with that as well, particularly the vast amount of alum, which is incorrectly described as a sizing agent, but we don't need to dwell on those. So then the claims, we have just seen the text of these in the consistory clause, and I will just summarise what I say about the claims. This claim 1 is directed to an article, a physical object. That article has been manufactured from a mouldable paper pulp composition that includes a detergent-resisting binding agent, but fundamentally that just means additive. We don't get too hung up on what binding agent means there. And there are 3 further limitations. The article is an open-topped washbowl. Second, the detergent-resistant additive comprises fluorocarbon. And third, the composition further comprises biocide. And we can zero in on the issue of construction, where the shoe pinches, so to speak, by reference to the disclosure of Shimooka. There's no dispute that Shimooka discloses containers moulded from paper pulp that includes a fluorocarbon that confers detergent resistance. There's no dispute that it would be obvious to add a biocide to that composition. So all that is left is the term washbowl. What type of container does that term have? And I have set out what I say about that at paragraphs 32 and 33 of my skeleton argument. And again, I hope I can just summarise. First, it's common ground that the term requires an article that is capable of holding soapy water for long enough to be useful as a washbowl. That's paragraph 13 of my learned friend's skeleton. So a container with a hole in the bottom, for example, might be a bowl, but it wouldn't be a washbowl. Similarly, a container made of raw paper pulp with no sizing agent whatsoever might be a bowl, but it wouldn't be a washbowl because it would be simply too absorbent. It would collapse immediately. So a degree of resistance to soapy water is one functional limitation imposed by the term washbowl. And in my submission, that leaves only the question of size and shape. And as I explain in paragraph 32 of my skeleton, at trial, I put a gloss on the claim by replacing the word bowl with the more general term receptacle. And with hindsight, that wasn't helpful, because as I've explained in my skeleton, as I'll come on to, it seems to have led the judge to misunderstand my case. So on appeal, clarity, I stick to the language of the claim, wash, bowl. And so far as shape is concerned, I say there's no hard and fast boundary, but I do say that the characteristic feature of a bowl, as compared to, say, the tray, is comparatively deep size. That chimes with its function of holding liquid. And as far as size is concerned, as also touched upon, I think it's common ground that a bowl at least the size of a cereal bowl will do. I get that from paragraphs 26 to 29 of my learned friend's skeleton argument. These don't deny that a bowl of this size can be a wash bowl within the meaning of the claim. Rather, they deny that it would be obvious to make a bowl of that size and shape over Shimooka.
So you don't say that the figure in Shimooka is a bowl, the specific figure?
I mean, speaking for myself, that looks more like a tray type.
Well, you're the person who counts, so... Yeah.
Well, so no, I don't make the submission that that is a bowl. I can rely on the general description and the variety and what the skilled person would conceive of without invention as suitable shapes. So I don't need to say that that shape is itself a bowl. So, so that brings me to the construction of washbowl that I articulate at paragraph 33. The term means a bowl suitable for holding water for use in washing. So it's hardly earth-shattering stuff. And please note, I do not say that anything capable of holding wash water can be a washbowl. I do not say, for example, that and we'll come back to that when we come to how my learned friends address my case and indeed the judgment. So my invalidity case, that's what I say about the central issue of construction, and having articulated that construction, my invalidity case is a short one. There is plainly overlap between the range of containers that are taught by or obvious over Shimooka and the range of containers that are covered by the term washbowl. A good example of a container within that area of overlap is a bowl the size and shape of a cereal bowl. Such a bowl would be well suited to holding a portion of food, soup, salad, pasta, cereal, for example. Bowls of various shapes and sizes already formed part of the skilled person's common general knowledge, so such a bowl is obvious over Shimooka. And that bowl would be indistinguishable from, for example, Vernacare's LA washbowl. And that really is it. That is why I say claim 1 of this patent is invalid. So with that, I'd like to turn to the judge's analysis and where I say he went wrong, and I hope I can take this now fairly swiftly. If we start at paragraph 80 of the judgment.
Sorry, 80.
80.
Thank you.
The judge raises the issue of construction. And you could just briefly remind yourself of what he says there. So he doesn't actually construe the term at this point. He says it's been subsumed into the broader debate about the inventive concept that arose in the context of the Pozzoli analysis. And before we move on to that, it goes without saying that identifying the inventive concept as per Pozzoli step 2 is not a substitute for construing the claim. It involves finding an acceptable shorthand for the claimed invention once the claim is properly construed. So if we turn now to paragraph 82, where the judge gets into the debate on inventive concept, at paragraph 83, he sets out Dr. Kelly's formulation of the inventive concept. And as I pointed out to the judge, a remarkable feature of this formulation is that at no point did Dr. Kelly consider the wording of the claims. They don't even appear in his expert report, so there was no indication that he had even read them, still less focused on them as the definitive statement of the invention. Rather, he seems to have reviewed the patent as a whole and to have advanced his formulation, and I'll quote from Connor and Angiotech, as a vague paraphrase based on the extent of the disclosure in the description. The judge then goes on to deal with my construction at paragraph 84, and you can see here my use of the term receptacle instead of bowl, which seems to have caused him to misunderstand my case. And this then emerges at paragraph 85, where he sets out his reasoning for rejecting my construction. So if you could just read that, because it is an important passage. You've obviously done that. So he understands my construction as covering absolutely anything that you could pour water into. And he says that can't be right. And I agree. That was not what I'd intended to say. I can perfectly well accept that the term washbowl does not cover any article capable of containing liquid, particularly where it is self-evidently adapted for some different purpose. So an egg box is excluded, as is a plant pot. And for the same reason, I don't say that the prior art baby bath, considered in the earlier Vernacare case, heard by His Honour Judge Burst QC, as he then was, is a washbowl. Even though it can obviously contain soapy water, it is recognisably something else. But of course, none of that deals with the status of a common or garden bowl that can be filled with soapy water and used as a washbowl if the user so decides, and is not recognisably something else. A bowl the size and shape of a cereal bowl, for example, and that's what I was hoping to emphasise then and now. So if we come on to paragraph 86, the judge sets out what he considers to be the focus of the claim, and in my submission, this passage makes precisely the same mistake Dr. Kelly made. There is no attempt in this passage to construe the term washbowl to identify the physical features that distinguish a washbowl from any other type of container. Instead, it leaves that question unanswered and moves directly to a paraphrase based not on the actual wording of the claim, but the specification as a whole. And sure enough, having made the same error as Dr. Kelly in paragraph 87, the judge goes on to explicitly accept his formulation of the inventive concept. So, ground one of my grounds of appeal, this is the judge's failure to construe the term washbowl at all. It's a sin of omission, so to speak. It was all well and good to reject my construction of the term on the misapprehension that it covered egg boxes and plant pots, but that does not excuse the judge from articulating what he considered to be the correct construction. Merely identifying two articles that are definitely not a washbowl does not suffice. The judge's task was to identify the physical features that distinguish a washbowl from any other type of container, because only once he had done that could he compare the claimed article with articles that were disclosed by, made obvious by the prior art. This he did not do, and in my submission that was a material error of law and or principle that fundamentally undermined his subsequent validity analysis. In effect, having failed to turn his mind to the actual scope of the claim, he couldn't ask himself the right question on obviousness, and he didn't, as I develop under ground two. So that's my ground
I'm having a bit
one.
of a problem with your notion of excluding from the claim things which are recognisably something else. So you say a baby bath is not because that's a baby bath, even though you could perfectly well, or rather efficiently, use that to wash somebody with. So, I mean, but if you're right that that's a relevant criteria one applies when determining the scope of the claim, why does one not look at Mr. Shimooka's sort of picnic set, his tableware, and say, well, that's recognisably something else as well?
Well, my lord, because what I say is, if you take the bowl out of that, so let's take the example of the salad bowl that might be included in that picnic set. If you take that article in isolation and you fill it with salad, it's apt to be called a salad bowl. If you fill it with soapy water, it's apt to be called a wash bowl. But that, you can't look at it and say that is clearly a salad bowl and not a wash bowl, because they are the same article. So, the reason that I've made that concession is, in a sense, I don't need to go there. I don't need to stretch my construction to cover articles which you would look at and you'd say, yes, I can pour water into that, but I can see that that's not what it is. That's how I answer that. If you take the article, if you take a physical article, and my point is that this claim, the skilled person has to be able to decide whether they're inside or outside of that claim simply by looking at the physical article itself, by the physical characteristics of that article. And there is nothing to, when one takes a common or garden bowl, whether one would describe it as a wash bowl or another type of bowl, rather depends on the context in which it's used. Or if you do fill it with soapy water, I say that and it would be apt to be called a wash bowl, that makes it a wash bowl for purposes of the claim. So that's my ground one. Ground two. The ground two error, I say, resides in the formulation of the inventive concept that the judge accepted, having failed to grasp the nettle of actually construing the claim. And I've quoted this at paragraph 42 of my skeleton argument. The judge's formulation was that a detergent-resistant wash bowl can be made using a fluorocarbon. And in my submission, that formulation is explicitly directed to a subjective insight. But of course, that subjective insight is not a limiting feature of the claim. As I've emphasised in the previous exchange with my Lord Justice Floyd, the claim is directed to a physical article. It is defined by physical features, and the state of mind of a person making or using that article doesn't come into it. So I say the judge's formulation of the inventive concept was wrong as a matter of construction and therefore wrong in law. And we can see the consequence of that error when the judge comes on to solely step 4 at paragraph 121 of the judgment. So if you could remind yourself of 121 and 122. So first, the judge records that the containers disclosed by Shimooka are detergent resistant in fact. And in my submission, that should have been an end to any further discussion of this feature. But having failed to construe the claim and having adopted Dr. Kelly's formulation of the inventive concept, the judge proceeds to ignore the fact that Shimooka's containers are detergent resistant in fact, and he proceeds to focus on whether the skilled person would have had the idea of using the fluorocarbon for this purpose. And that's why I say he asked himself the wrong question on obviousness. That is not the question posed by the claim. And I say that's entirely irrelevant. It was obvious. Indeed, the whole point of Shimooka is that you add the fluorocarbon to make the article suitable for containing oily food. There's no dispute that the skilled person would want to do so for that purpose. There is no dispute that the result is a detergent-resistant container, whether the skilled person knew it or not. And that is why I draw an analogy with Hallen and Brabantia. The claim is directed to an article. It is not a purpose-limited claim. It is therefore enough that it be obvious to make that article. So my submission.
Your point is really that whether or not they appreciated why they were getting a detergent-resistant washbowl isn't relevant. What the judge should have addressed himself to is what the skilled person in fact gets as a matter of routine from Shimooka.
My lord,
And ends up with something that he doesn't appreciate as detergent resistance, but it does.
But it does. My lord, that's precisely the point. And so it's for that reason that once he had found as a fact that these bowls were detergent resistant, that should have been an end to the debate, and that would have left, or should have left on the correct approach, only the question of whether among the range of containers taught by or made obvious by Shimooka, there are any bowls that would be suitable for holding wash water and are not obviously recognisably adapted for some different purpose. A bowl the size and shape of a cereal bowl, for example, and I say there plainly was. But of course, as a result of the errors that I've sought to explain, the judge just didn't turn his mind to that question at all. Instead, he asked himself the erroneous question that we've just looked at, and then he comes to the erroneous conclusion in paragraph 22 based on irrelevant matters of subjective insight that he articulates at paragraphs 123 and 124. So that's my ground 2.
Can you just enlighten me on this? Was Hallen and Brabantia cited to the judge?
From memory, it was not, but I can check and send a note perhaps after the hearing. Now, and I do say that these grounds, if accepted, warrant reversal of the judge's conclusion on the validity of Claim 1. So before I move on to ground 3 and Claim 9, I would like to say a little bit in answer to Vernacare's skeleton argument, which seeks to defend the judgment against my grounds 1 and 2. And as I read the document, there are really 3 main points advanced in answer to the appeal. And the first, you can get the basis for it at paragraph 13 of my learned friend's skeleton argument. Second, so this records that it's not in dispute that a washbowl must be capable of holding soapy water. And then this paragraph. Ground 1 of MFP's appeal is based on the proposition that anything which could be used for holding soapy water is a detergent-resistant washbowl. Now, with respect, I really fail to see how my learned friends can extract that proposition from my skeleton argument or grounds of appeal. I've been quite clear in acknowledging that not everything that can be used for holding soapy water is a wash bowl. We've been through the examples of egg box, plant pot, baby bath. What I'm interested in is the common or garden bowl.
If we substituted the word any bowl for anything, then it would be accurate.
Then it would be a fair characterisation of what I say. And that is the case that my learned friends need to deal with. That's the case they haven't dealt with. So this whole aspect of their answer, purported answer to the appeal, is a straw man. And if we look at their purported answer to my second ground, it adds absolutely nothing. So this is paragraphs 15 to 17. At 15, this merely recites the judge's formulation of the inventive concept. 16, very bald, manifestly correct. And 17 merely repeats the straw man. So actually no answer at all in here to ground 2, other than to mischaracterise my construction. And what is conspicuously absent in these paragraphs or anywhere else in this skeleton argument, despite everything I have said in my grounds of appeal and my skeleton argument about the need for a positive construction of the term washbowl, is any positive construction of the term washbowl. My learned friends doggedly stick to the approach of ducking that issue altogether, and then by way of developing their rebuttal of the straw man argument, they then rely on the Hickman and Andrews case for the proposition that one must not use ex post facto synthesis of the prior art to build up an anticipation that fits the claim. I say that's rather rich, considering they don't tell us what the claim actually requires. But even so, Hickman and Andrews does not help my learned friends at all. There the claim was to an article termed a workbench, and the commercial embodiment of that workbench was the Black & Decker workmate. And if you've had a look, you've seen the diagrams of it. It was a very clever.
Some of us have got one in our garage.
Because I only had to look in my own garage.
Yes.
That said rusty and unused, but definitely a Black & Decker workbench.
Acres of formica sawn on these devices in the 80s and 90s. But the point there, if you're familiar with the design and you've seen it, I can cut through this. The point is, it had legs that supported a work surface at about waist height, and you stood next to it and you worked on your workpiece. So it was, in a conventional, although it had novel features, it was a workbench, and that's what one would naturally describe it. And the prior art was a bookbinder's clamp, and you can't see the pictures of that very well in the report that you have, but I have scrounged some RPCs from chambers that have better pictures if you'd like to look at those. Or are you familiar with the article?
I think we are, but it'd be sad not to look. Now you've been so
For old
kind as to
time's
bring
sake,
it.
So
I
for
think
this
Sir
one,
Christopher will
for this
be
one,
more familiar than I am.
we can thank Mr. Purvis, but it does even in the PDFs that you download from Westlaw, these are rather blacked out, these images, but these give a much better sense. Can I hand this up?
Yeah, and we're obliged for the original because these things don't photocopy very well either.
No, I tried that too, and it didn't help. So I hope you can see from these, if not the report,
Thank you very much.
authorities, that the prior art in that case was a bookbinder's clamp. So that article, it's not a bench, it's called a laying press, but in a sense, in essence, it's a clamp that's used to clamp the pages of a book while it's being bound. So at least in days gone by, when you sent your RPCs to be bound, this was the device that put the loose copies together to turn them into a book. So on any view, that isn't a bench. It's a clamp that's designed to sit on the top of a bench or a table or some other surface and clamp leaves of paper together. It's a tool. So one can perfectly understand why the court in that case said it wasn't a workbench and it was an ex post facto synthesis to suggest that it was, even though in principle it could have been used to clamp small pieces of wood. Fundamentally, it was a qualitatively different kind of article, and that's not this case. It works for the straw man argument. It doesn't work for the actual case that I'm running here. What we're concerned with is bowls. They're not qualitatively different types of article. They're the same kind of article, indeed, discussed with Lord Justice Floyd, the same article. So Hickman and Andrews really isn't an answer to my appeal. The second point that my learned friends develop is that Shimooka does not disclose, and it wouldn't be obvious over Shimooka, to make a bowl of the requisite size and shape. And that's paragraphs 26 to 29 of my skeleton argument. I've been through that.
Yes.
And why I say that's wrong, I don't need to go that again. And the third point is a state of mind point, and this is articulated oh so briefly at paragraph 30 of my learned friend's skeleton argument, and this seems to be their final backup point. Furthermore, even if a cereal bowl-sized food container were to be made, it would not be a wash bowl because the skilled person would not expect it to be and would not know that it was detergent resistant.
You'd hope it might be if it was a cereal bowl, however. You would hope it might be if it was a cereal bowl, however.
Well, quite. But fundamentally, this is reviving the judge's focus on the state of mind of the skilled person, and I don't understand what this means as a matter of construction and how that construction would work in practice. How would one know whether one was within the claim? But fundamentally, that matters not. I say it's simply wrong in law. This is not a claim that is limited by reference to a state of mind. It's limited by reference to the physical features of an article. And so, paragraph 30, however that works, I say that is no answer to my appeal. So those are my grounds 1 and 2, and what I say about my learned friend's case. That brings me on to my ground 3.
Yes.
And this concerns the independent validity of claim 9. We can turn that up in the patent, but essentially it's to the broadest claim that we just saw at the top of, the broadest range rather that we just saw at the top of page 4 of the patent. And as I pointed out then, the range is defined by reference to the volume of the liquid carrier, not by reference to the active ingredient. And my learned friends adduce no evidence at trial to support the independent validity of this claim, save to say that the use of fluorocarbon in moulded pulp compositions was not common general knowledge. That was Dr. Kelly's evidence, but he gave no evidence that was specifically directed to the claimed dosing range. So essentially what he said was, look, a skilled person had never used fluorocarbons in moulded pulp before. That wasn't obvious, and it follows that any points of detail associated with that isn't obvious. So I do say, given that no evidence was specifically directed to the ranges in this claim, my learned friend can only rely on a presumption of validity in his failure. And given that it is a subclaim, I do suggest that presumption ought not to be especially strong. But fundamentally, the question for the judge was whether my evidence was sufficient to rebut that presumption. And I'll show you Professor Hearn's evidence on this. That's at tab B, paragraph 26, tab 26, paragraph 2.7. It's tab 27, paragraph 2.7.
Thank you.
And what he is doing here is responding to Dr. Kelly's evidence that the use of fluorocarbon in moulded pulp compositions wasn't common general knowledge. And he says this: the use of fluorochemical sizing agents in paper pulp products is discussed in depth in the available literature. I refer to the contents of my first report. The dosages stated in section 57B of the report would be obvious to try to any skilled person. So this is what he said. Now, I accept that Professor Hearn's evidence on the skilled team, composition of the skilled team, was rejected, with the result that the skilled person is not a formulation specialist who would themselves consult formulation literature of the type that Professor Hearn is referring to here. He was a skilled paper chemist, and he took the view that this patent needed a skilled paper chemist. The judge rejected that. But for the purposes of implementing Shimooka, I say that doesn't matter, because it was common ground that the skilled person who's a moulding specialist would seek specialist advice on additives as needed. And the judge records that at paragraph 27 of the judgment, so we don't need to turn that up. Shimooka is teaching a novel pulp composition to a moulding specialist who isn't an expert in pulp compositions, and Shimooka does not teach any dosing range for the fluorocarbon. It simply says put some in formulation. So the skilled person, on the basis of the judge's own findings, the skilled person would have to consult somebody who knew what they were doing on dosing range. In other words, even though this person wasn't part of the skilled team, the skilled person would have to consult somebody with the specialist knowledge that Professor Hearn is referring to here. And what he's saying is it would be obvious to try any of the ranges, any of the concentrations or dosing levels that are covered in the claim.
But if the claim doesn't define how much active ingredient, as it were, is there, it's just a volume of liquid which may have virtually nothing or maybe virtually neat.
Just so.
Then how can you say it's obvious? Obvious to do that in particular.
Well, I mean, perhaps I was going to come on to that at the end and explain how that feeds into my conventional obviousness case. But what I wanted to emphasise before I move on to this is that this passage of evidence was entirely unchallenged. It was never put to Professor Hearn that this would not be obvious at all. So this was unchallenged evidence, and I say it was the only evidence that the judge had that was specifically directed to this range. And I say that it is enough. That was enough to rebut the weak presumption of validity of the claim, and that the judge had no basis for rejecting it. But I'll come on now to look at how he dealt with the claim, and that's paragraph how he dealt with the independent validity of this claim, and that's paragraph 128 of the judgment. And if you wouldn't, I'm sure you've read this, but if you wouldn't mind just briefly skimming it to remind you of some of its
Paragraph
content.
128.
Paragraph 128. So what the judge records here is a point I made in closing, which I accept I didn't plead, which is that the claimed range is arbitrary precisely because it isn't tied to any particular quantity of active ingredient. So it can't be associated with any independent technical effect across its scope, because it doesn't add anything to the basic idea of including some fluorocarbon in the composition, and that's already there in Claim 1. And what I say about this paragraph of the judge's reasoning is that he seems to have thought that this was my only attack on the independent validity of the claim. And he says it wasn't pleaded, so he doesn't consider it. But as I've showed you, this was not my only attack on the independent validity of this claim. There was unchallenged evidence of obviousness on entirely conventional grounds. I draw the judge's attention to that. And he's ignored that altogether. He's certainly not explained why that evidence was not sufficient to rebut any presumption of validity. All he says is nothing in Shimooka to suggest the claimed range, but of course Shimooka says nothing about ranges, which prompts the skilled person to go and ask, and he hasn't referred to his own point on the consultation that would follow from that. So fundamentally, I say the judge has overlooked this evidence. It was the only relevant evidence on the point. He should have accepted it with the result that he should have held Claim 9 to be invalid, and that is my ground 3. But in answer to my Lord Justice Floyd's point, I do say this: even if it wasn't open to me on the pleadings to run a formal aggrevo attack on this claim, i.e. to assert that there was no technical effect associated with the range, the same point, I say, does support my conventional obviousness attack, because one way or another, the skilled person has to pick an amount of fluorocarbon, active ingredient, to add to the formulation. And the amount of liquid carrier they use for that is a question of happenstance, dilute, not dilute. So fundamentally all I say is this: there is absolutely nothing to stop the skilled person ending up in this claim by accident, whatever the quantity of fluorocarbon they actually want to use. One can imagine, simply as a matter of happenstance, the skilled person adding the active ingredient, using an amount of liquid carrier with it, which is within this claim. That would require no invention whatsoever. So I do say, to that extent, I can rely on a similar point to support my conventional obviousness attack. So,
and this is all starting from Shimooka, so in that sense it's not outside your pleading at all.
my lord, yes, in that sense it's not. I mean, I suppose perhaps a higher standard the judge might have felt that it was appropriate to impose a higher standard because we were in the IPEC, but there it was. I did say obvious over Shimooka. So, my lady, my lords, unless I can assist you further, that is.
No, thank you very much indeed. Yes, Mr. Hicks.
Well, again, I was proposing to deal with matters broadly in the order in which they appear in my skeleton, and in the course of doing that, I'll endeavour to pick up points that my learned friend has made in the course of his submissions.
Thank you.
And the substance of our skeleton begins in paragraph 7 to 12 with the disclosure in Shimooka and the common general knowledge. And could I invite you to begin by turning to Shimooka, and I know you will have read it, but there are a couple of additional passages that I want to highlight. So Shimooka is at B21, and if I could pick it up at page 409 of the bundle, which is the
Bundle B, is it?
bundle B, yes, sorry. Bundle B, tab 21, and the document starts at page 408, but the description and the claim start at
Thank you.
Let me just invite you to bear the following points in mind. First is paragraph 1. It relates mainly to a sheet made container made from raw material, mainly consisting of pulp, and then in particular to a short time use tray-shaped or cup-shaped food container with excellent water and oil repellents. The point being that it's a tray-shaped or cup-shaped container. And what my learned friend is doing is, by a process of hindsight reasoning, inviting you to infer that the target is something that would be a wash bowl, or suitable for use as a wash bowl. That is not the described target of Shimooka. It's a short time use tray-shaped or cup-shaped article. At the top of the right-hand column in 400 and on page 409, there is the passage my Lord was referred to of disposable food containers used as single-use tableware at picnics and parties. It's referring to tableware made out of styrofoam or plastic. And then at number 3...
You dispute tableware includes bowls?
No, I don't. It could include a bowl.
Wise man.
I do dispute, though, that a wash bowl would be considered to be tableware, which is a different point. Could I then invite you to look at paragraph 3? And what paragraph 3 is referring to is how you could make food containers out of paper. In the world of packaging, what a layperson might call thin cardboard, they call paperboard. What paragraph 3 is referring to is the ability to press paper, thick paper, into a shape. And my learned friend gave you the example of what we would call an old-fashioned paper plate. which was fairly shallow and was created by pressing. You had little scallop-shaped indentations around the side where the pressing took place. And then
You also had bowls made in that way, which had jelly in them at children's parties.
yes. I don't know whether they were made by a pressing process or whether they were made by some other form of moulding process. And what my learned friend is doing, there was little evidence directed to this. What my learned friend is doing is constructing a case based on Shimooka out of an argument based upon no evidence as to exactly what someone trying to make food containers, what range of shapes they would make.
But it tells you in paragraph 4 you could have a product with a deep bottom.
It can be a deep
degree of freedom of shape can be expanded.
Indeed, and what it's saying is we say that's in contrast to the relatively flat pressed shapes. It can certainly be deeper, but it's deeper relative to the materials described in paragraph 3, the pressed containers. So certainly deeper, and certainly you could create a product with partitions in it. That's an advantage. But we say the depth, if you read this as a skilled person interested in tray-shaped food containers, disposable food containers, it would be deeper. But that's about as far as it takes you.
But wouldn't you be interested in the last part of the sentence that says, and the degree of freedom in shape can be expanded?
Yes, it's better than mere pressing. Absolutely, it's telling you you have more freedom than mere pressing, but it is comparing it with the pressing.
So in terms of shape, you're told you can make a bowl.
You're told you could probably make a bowl, a food bowl, but that does not mean that it would be suitable for use as a wash bowl. As I say a bowl, you're told you can make a tray-shaped container. If one calls that a bowl, you're told you could make that. You're not told in terms, we submit, that you can make what someone might more conventionally call a bowl. If I could, now I can put Shimooka away now because the judge summarises a lot of it, and if I could turn to the judgment and just take you to how the judge deals with Shimooka. The judgment's at tab 5.
One thing in Shimooka before you go on that
Yes.
you haven't addressed is Mr. Orkin relied upon the references both in the abstract and in paragraph 26 to the statement that you can make containers with a, quote, wide variety of shapes.
You can, but we say in context when you read the opening paragraph, what its target is, and paragraph 3, which is what it's comparing with, it's tray-shaped containers.
But can I be clear? Is it your case that when the reader sees a wide variety of shapes, they understand that that does not include bowls?
They would say that it includes a bowl which might be deeper or something that could be used as a bowl of a type. Depends what one means exactly by a bowl. If by bowl one means something deeper than a paper plate, we fully accept that. But we would not accept, for example, that the specific example shown at the end of Shimooka is a bowl. We would say that would be perceived by a skilled person as a tray, a bento box type product. So we say it has to be read in context, and what we say MFP is doing is by a process of hindsight reasoning, say food container is bowl, bowl equals wash bowl. We say that's setting the target by reference to what one knows the invention is. Now, could I come to the judgment, and just so I can show you how the judge dealt with Shimooka, and I know you'll have read it. It starts at paragraph 108 judgment. And we can see over the page, at page 81 of the bundle, he reproduces figure 1 of the patent, and then at 110, the first paragraphs 3 and 4, and then at the top of page 82, paragraph 111, this is the nub of Shimooka, that if one adds a fluororesin, one, as the judge says at paragraph 113, can see that the product has excellent water and oil repellents and can hold food containing water and oil.
Can you help me on this? So far as I can see in the passage describing the disclosure of Shimooka in the judge nowhere refers to the parts that say you can make it in a wide variety of shapes. Is that correct?
He doesn't recite that. He does recite paragraph 4, where he says there's a degree of freedom. So he's aware of that.
Thank you.
So he does set out paragraph 4. But he doesn't specifically recite the abstract or the paragraph at the end. But he's well aware of paragraph 4, which shows what the improvement over paragraph 3 pressed paper plates type products consists of. While we're here, although Sugimoto is not an issue, if one has a look at page 82 and 83, one can see the parallel pattern, same company. It shows an example of what one might consider a tray-shaped product with multiple containers.
And by the priority date, which is the date we're considering, what was on the market in terms of moulded paper products?
Well, there was packaging, which we've seen, egg boxes, that kind of thing.
Well, there was your client's LA wash bowl.
It
was the size and shape of a cereal bowl.
Can I just say that it was called the LA bowl. It wasn't marketed as a wash bowl, although it.
Sorry, if it's called a wash bowl,
it wasn't.
How was it not marketed as a wash bowl?
It wasn't called a wash bowl. It was called an LA bowl.
So it's just Miss Turner Gardner who referred
yes,
to it as a wash bowl.
yes. She said she explains it could be used, but it was not marketed or described as a wash bowl, and there's no evidence.
But she says it was used as a wash bowl.
She said it could be used to wash patients, but it was not marketed as a wash bowl.
All right.
It was marketed.
But can you tell me? I understand your point. It wasn't marketed as a wash bowl, but in what respect was it not suitable for use as a wash bowl?
It could be used as a wash bowl, as she says.
But we were told, she told us it was too small. And it disintegrated.
Yes.
Made it pretty limited in its value.
It was limited in its value. She explains that it could be used in a limited situation, which the judge summarises in paragraph 94 of the judgment.
Just from the point of view of moulding, that's an example of something which is bowl-shaped and has the depth. So it wouldn't come as any surprise to the person reading Shimooka that you could make things with deeper bottoms.
It wouldn't come as a surprise to someone reading Shimooka that you could do it. The question is, someone reading Shimooka, would they have the incentive to do it, bearing in mind that what Shimooka is doing is telling you that it should be oil grease resistant. That's what Shimooka is.
And water resistant.
And water resistant. But it's known that products are water resistant. What's the problem? The problem that the patent solves
The detergent.
is detergent or soap resistant. That's the problem. So what Shimooka is telling you is you can make a food container, specifically referring to tray shape, but a food container which will be water and oil resistant by the addition of fluorocarbon. It's not telling you in terms that you can make a wash bowl. It is known that you can make bowls that hold water from a moulding process. That's known. So that's the difficulty with the evidence we say my learned friend faces. He hasn't explained on what basis a skilled person reading Shimooka at the time would have the incentive to make something that was of the requisite shape and size to be a wash bowl. It would be a food container.
So I'm sorry, I'm sure I'm being dense, Mr. Hicks, but I'm struggling to understand what is missing in terms of size and shape, because you've accepted that a cereal bowl is tableware. So if you make something which is of the size and shape of a cereal bowl, and we can see from Ms. Turner Gardner's evidence that you can also use that for washing, which is common sense anyway, what is missing in terms of size and shape?
You need something. So if it's a bowl for holding, perhaps let's have a look at what Ms. Turner Gardner actually says. That's at page 30. That's at page 17 of my learned friend's skeleton. Yeah, page 17, paragraph 40. She's talking about volume size. It's got to be suitable. So to be a wash bowl, it's got to be suitable for a nurse or somebody to be able to fill it with water, transport it to the patient, and perform a washing operation.
So I'm sorry to be distracted by terminology.
Yes.
And one shouldn't be, but nevertheless, can I be clear? She describes the item as, quote, LA wash bowl. She was your witness.
Yes.
So you're telling us on instructions that your witness's evidence as to the name of the product was wrong. Is that correct?
She was a fact witness, and she was just using this as a reference. My instructions are that it was marketed as an LA bowl.
Well, that may be your instructions, but was there any evidence before the judge to contradict your witness's use of the term LA wash bowl?
There was a notice of models in which it was referred to as the LA bowl, but there was no other evidence directed to that particular point.
I mean, given that she puts it in LA capital W wash capital B bowl in quotes, looks like she's quoting the trade name, doesn't it?
It looks like that, but that is not what the name was. It was put in as a notice of models called the LA bowl, and there was no documentary evidence or any other evidence introduced to say that it was marketed as a wash bowl. It was marketed as a general purpose bowl, which is a polite name that's used in hospitals, particularly for vomit bowls. It's used as a general purpose bowl that might be utilised in hospitals. It could be adapted.
But she says it's the only moulded paper wash bowl of which she was aware.
Yes.
So she's plainly regarding this is your witness, she's plainly regarding it as a lowercase w, lowercase b wash bowl.
I'm not disputing. She's saying that the LA bowl could be used, although not ideal.
She says the only moulded pulp wash bowl of which she was aware was the LA wash bowl.
It was not a wash bowl in the sense required by the patent, and this was common.
Why not?
Because it was not detergent resistant. And
But that's a different point, Mr. Hicks. Of course, it doesn't have the detergent resistance element of the claim. The question is it a wash bowl?
That's right. Well, it's common ground that wash bowl, as interpreted in the context of the patent and as used in Claim 1, means a detergent-resistant product. This product is not a wash bowl in that sense. It could be used, it's a general purpose bowl that could be used in a limited way to wash a patient, but it's not a wash bowl within the meaning of Claim 1.
Was the notice of model in the bundle?
It was in the trial bundle, but it's not in the appeal.
No, I
And
appreciate that. But I just
over the
wondered-
short adjournment, I can, if we're permitted to.
I mean, a notice of model is not evidence. It's simply a notice to the other side of something you're going to rely on.
That's right. There is no documentary evidence of which I'm aware, or any other evidence.
But there doesn't need to be, does there? Because you have evidence from a fact witness, who is your own witness, who tells us what the answer is.
She tells you that she used it, or it was used on some wards to wash hands and faces. It tells you that. It's a general purpose bowl, but it's not a wash bowl within the meaning of the claim, because it is simply not detergent resistant. And it was common ground, and this was dealt with in the pleadings, that as used in the patent, wash bowl in the context of hospitals meant something that could be used to wash patients with soapy or
But
detergent.
if it had been detergent resistant,
If it had been detergent
then
resistant,
it would be a wash bowl within the meaning of the patent.
Yes, it would be. If it had been detergent
And
resistant.
the product of Shimooka is detergent resistant.
Yes,
Why is it not a wash bowl within the meaning of the patent?
because Shimooka is not telling you, we say, to make a product of a shape and size which a skilled person in a hospital, would consider to be a wash bowl.
So it does comes back to shape and size.
Comes back to shape and size, because one has to bear in mind what a wash bowl is in the context of the patent. It's something that can be used to wash a patient using soapy water.
Right, so can you tell us, what is the size and shape of a wash bowl? Please give us your definition.
A typical size, as the experts explained, is about 4 litres of water. I can show you the evidence for that, if that would be of assistance.
So you say the claim is limited to a wash bowl that contains 4 litres?
No, it's not. It's limited to something which a skilled person would consider to be a detergent-resistant wash bowl suitable for washing patients. That's what the limitation is.
So Miss Turner-Garden was wrong on 2 scores then. She was wrong to call it a wash bowl because it wasn't detergent resistant. She was wrong to call it a wash bowl because it was the wrong size to be a wash bowl.
Well, she says it had a limited use other than for hands and face.
You say it's not a wash bowl.
Well, it's not a wash bowl
It
because
doesn't have the size and shape which are in context required by the term in the patent.
but the LA wash bowl, as she calls it, is marketed as a general purpose bowl, is not detergent resistant. It could be used for the purpose to which it was not intended in the way she describes it. But this is why we say...
Can I be clear? You say the claim excludes washing hands and face.
No, it would include washing hands and face.
So if you have enough water to wash someone's face or hands, that's good enough, yes?
Yes, if the product would otherwise be seen by someone in a hospital as a wash bowl. This is why we say that anything which contains water or is a bowl does not automatically become a wash bowl. It becomes a wash bowl if it is of a size and shape that someone would consider to be a wash bowl. That's what makes it a wash bowl, and it has to be detergent resistant.
This seems to be an entirely circular definition. A wash bowl is a wash bowl. That's your definition. You can't tell us the shape and you can't tell us the size.
One might, there's clearly a range of sizes, but that happens with many claims of this type. If something is a hammer, it can come in a range of shapes and sizes. But the ultimate question you have to ask yourself is, would the skilled person call it a hammer? I'll come to the previous Vernacare case where His Honour Judge Bursus, he then was, dealt with two similar points. So I've taken you to the judgment. Could I just, and I know you'll be familiar with this, take you to the skilled person and the common general knowledge. There's absolutely no dispute about it, but if one goes back to paragraph 23 of the judgment, which is on...
I'm sorry. I don't want to pile in when you on the challenges, but for my part, as you will gather, a non-expert in this field, I thought it would be helpful for me just to have a look at Ms. Turner Gardner's evidence.
Yes.
Just so that I could understand the context and look at the paragraphs before and after and how that fitted together.
Yes, yes.
Which rather discourteously, when you were batting back the questions, fielding the questions, I should say, I read on. And I noticed that at paragraph, I'm looking at page 424 in tab B, which is her written material.
Yes.
And at paragraph 22, she tells us all about the, soggy bowls, whether they be wash or otherwise, and the problems that cause. And then she says, well, I don't recall the exact manner and timing of when feedback was given to your lay clients on the preceding wash bowls, non-detergent resistant paper. I recall being in focus groups, etc., etc.
Yes.
It's we are perhaps going in circles, but it does seem to me that whatever the marketing name was, these earlier modern non-detergent models were regarded, not just regarded as wash bowls, but then this witness assisted as an infection control expert with your company to develop something that was going to be more satisfactory.
Yes. So she refers to detergent-resistant plastic. The detergent-resistant wash bowls before the Vernacare.
No, she says non-detergent-resistant paper. Or
Yes. So I'll deal with the paper in a moment. But she refers to detergent-resistant plastic, which was the known wash bowl. She's referred to non-detergent-resistant paper. It was not useful as a wash bowl, not satisfactory as a wash bowl, because it was not detergent resistant. It would disintegrate within moments. But the point is that in the IPEC, the point was dealt with in the pleadings. Both sides accepted that to be a wash bowl, it had to be a detergent resistant product. So she's using it in one sense, but the patent is using it in another sense.
So at the end of that paragraph, relating to the wash bowl product, there was a lot of discussion as to why a new disposable wash bowl was needed. So you're saying that she's using wash bowl as the same words, but effectively different terminology.
Yes.
Thank you.
Yes.
Thank you. Sorry to interrupt you. Now, where have we got to?
Yes. Could I just take you to deal with this to bundle A, tab 19, page 396.
Thank you.
19.
Yeah, it's the final tab. Page 369.
Three.
369.
Okay.
So this
This is the reply.
So this is Moulded Fibre Products pleading, and at paragraph 4, it's made clear that on the defendant's case, this is on MFP's case, uply open wash bowl as used in one pattern and open top wash bowl as used in the other have the same meaning. Generally planar base and upstanding peripheral wall capable of attaining a volume of soapy or detergent containing water for clarity, open top detergent. So it was common ground, and that's referring to our pleading as well, that in the context of the patent, it meant detergent-resistant washbowl.
Thank you.
I was going to go back, I'm sorry, to the judgment, just to take you through some points. At page 61 of the bundle, of paragraph 23 of the judgment, there the judge sets out Vernacare's submission as to the skilled person. And that was accepted by the judge as the correct version of the skilled person. If one reads on to paragraph 28 at the top of page 63, he says, for these reasons I agree with Vernacare's case that the skilled person for both patents is the person identified by Dr. Kelly as person 1. That's broadly as set out in paragraph 23, but I can give you the reference in Dr. Kelly's report to that. It's bundle B, tab 25, page 447, paragraph 15. Then, so far as the common general knowledge is concerned, turning to paragraph 94 of the judgment, the judge makes the point in paragraph 94, there's no evidence as at 2006 of any product being made from moulded paper pulp whose composition included a fluorocarbon. So the point about that is that NFP could find no evidence of an actual product being made. Shimooka and Sugimoto are what we'd say are pure paper publications, and no more than that. And that's why one, we say, has to be very careful to avoid a process of hindsight reasoning. To say, with hindsight, I can see that Shimooka is telling me this. In fact, there is no evidence that anybody actually implemented either Shimooka or Sugimoto. At paragraph 95, he makes the point that while it was known in the wider paperboard industry, so that's the layman's thin cardboard industry, to add fluorocarbon to make something more resistant to oil, water and grease, this would not have been part of the CGK of the skilled person within the moulded paper pulp section. So it was not part of the CGK that you could achieve what Sugimoto says you could do by adding a fluorocarbon.
How does that help you?
It merely just means that the only thing one has to go by is Sugimoto. There is no other basis for the attack. I'm not saying it makes it any different, but one has to bear in mind that the only thing is
Mr. Orkin isn't advancing any other attack.
No, there isn't, no. But the point comes to incentive. There is no incentive for anybody to do anything other than read Sugimoto and do Shimooka or Sugimoto to do whatever they say you should do. And then the fourth point the judge makes is at paragraph 96, that even if the skilled person in the moulded paper pulp sector had been aware of it as a way of introducing grease resistance or water resistance, they would not have known that it was likely to provide detergent resistance. So the point about that is that nobody reading either the two Japanese patent applications would have any idea that this was going to produce something which was detergent resistant. There was absolutely nothing in them which points you to making a detergent resistant washbowl. The case turns on the question, ultimately, of whether, without hindsight reasoning, following the disclosure of the two Japanese patent applications, the skilled person is told to make a bowl, a tray-shaped container, which in fact would be considered by those skilled in the art to be a washbowl, a detergent-resistant washbowl. It would be if one made something according to the Japanese applications. But there is nothing that tells you to make that. And this is what is an unusual feature of the case. It depends upon the skilled person making something with one target and it being, we would say, a different product, a washbowl. And that's the leap that my learned friend, we say, cannot bridge by a process other than a process of hindsight reasoning. Now, could I just deal with the authorities that we've mentioned very, very briefly? The first is, well, I might as well deal with Hallen and Brabantia first of all, to get that out of the way. So that's at tab 2 of the authorities bundle, page 58. And we deal with this in paragraphs 23 to 24 on skeleton. So tab 2, page 58 is this. Tab 2, page 58. That's claim 1 of the claim in Hallen and Brabantia. And it's for the quite well-known product, the screw pull corkscrew. And the idea of the screw pull corkscrew is that with conventional corkscrews, one screws the corkscrew into place in a cork and then pulls the corkscrew to pull the cork out of the bottle. The idea of Hallen and Brabantia is that one screws the corkscrew into place, but one continues to screw it, and the process of screwing it into place withdraws the cork from the bottle. And so claim 1, it's set out on page 58, 928, apparatus for extracting a cork from a bottle comprising a corkscrew, comprising a helical body and an outer layer of friction-reducing material. And then at 45, there's the inventive part of it, the corkscrew being a length such that when an abutment means engaged, so to limit downward movement of the corkscrew, said corkscrew intends into said cork receiving opening, whereby said cork may move readily upwards on said corkscrew as said corkscrew is rotated to withdraw said cork from said bottle. So there we are. It's adding an outer layer of friction reducing material, and the judge, may I just say that if one looks at claim 1 in the judgment of the Court of Appeal, there's a mistake, and it's easier to look at page 58. I'll show you the mistake in a minute. If one looks at page 69 of the bundle, this is, as Justice Aldersey then was at the bottom, line 46. In the present case, there was no problem in applying PTFE to a helix, nor, in my view, realising that if it was applied, it would assist penetration. So no problem in realising that adding a friction-reducing material to a corkscrew would help it drive into the cork. What the plaintiffs did was to realise that not only would it help penetration, but it was assist extraction, thus making a corkscrew which had little commercial attraction to a manufacturer into a product which sold in substantial quantities and had been widely copied. And then this is the key point. However, if it was obvious to coat the helix for good penetration, then the added advantage of good extraction cannot make it any less obvious to coat helixes. So the point is, merely because there is an unexpected advantage doesn't mean that a patent is not obvious, if in fact it is obvious to construct the product in that particular way for another purpose. And the Court of Appeal judgment starts Court of Appeals judgment starts at page 76 of the bundle in the next tab. I could just take you to page 86, where the claim is set out. At line 39, there's a typo. It should say a corkscrew comprising a helical body and an outer layer of friction-inducing material. Lord Justice Slade at 90 refers to the passage at the first instance judgment from Mr. Justice Aldous. That's the marked up passage from lines 15 to 29. And then further on in the judgment, at page 97 of the bundle, page 216 internal, they describe what's called the golden bonus, that an added benefit will, however great, will not found a valid patent if the claimed invention for obvious is another patent. Now, there's no suggestion in this case that anybody would want to make a washbowl oil or water resistant, because that water resistance is known already, so that's not a problem. Oil resistance is not something which the skilled person is interested in. What the patent deals with, which is not the subject of the disclosure of the two Japanese patent applications, is detergent resistant washbowl. So the difference between Hallen and this case we submit is that in Hallen the target always was a corkscrew of a particular type is obvious, and the mere fact that it has an additional golden bonus doesn't make it any less obvious. The target of Shimooka and Sugimoto was a tray-shaped container for food, not something that would be useful in hospitals as a washbowl.
So your claim is limited to bowls for hospitals, is it?
That's absolutely. Can I just show you the previous judgment? It's not disputed.
Sorry.
Primary.
Which words in the claim say that it's limited either to washing human beings or use in hospitals?
The primary target for such a product, there's no evidence that anybody else would be interested in a washbowl that was detergent resistant, is for use in washing patients in hospital. There's no evidence that anybody else is interested in having such a product, a maceratable, disposable, one-time washbowl.
Which words in the claim limited to hospital use and washing human beings?
It's a matter of interpretation. Washbowl in the claim in the context of the patent as a whole. Perhaps
right, so can I be clear? In summary, your submission is as follows. When we see the word washbowl in the claim, it, first of all, has to be of a particular size and shape, although you don't tell us what size and shape. Secondly, it has to be detergent resistant. And thirdly, it has to be for use washing patients in a hospital.
It doesn't have to be for use in washing patients in a hospital. That would be the primary class of person who would be interested in maceratable washbowl.
So if I use one of your client's products to wash my car, it ceases to be a washbowl, does it?
If it is a washbowl, it doesn't cease to be a washbowl merely because you use it to wash a car. But washbowl in the context of the patent means something that's going to hold detergent. And if one chose to wash one's car with a washbowl that was made by the party.
And one does frequently use detergents for washing cars.
Yes, but the point, perhaps I'm confusing 2 points here. What does a washbowl mean? It's got to be something which is detergent resistant in the context of the patent, and the patent's talking about washbowls for washing human beings. That's the primary interest of it. And when I say there is no limit on the volume, I'm not saying that there is a precise limit on the volume, but there is a limit implied by the word washbowl. And perhaps if I can show you the judgment from the previous case to see how His Honour just first dealt with similar points. So that judgment is it's a tab 4 of the authorities bundle. And it starts at page 101. Now, this is about the parallel patent. If I could show you at page 105 what is said in paragraph 12, where claim 1 is set out. It refers to an upwardly open washbowl manufactured from maceratable dried paper pulp. And this patent is dealing with the configuration of the walls of the patent. And one can see at paragraph 13 that because it's made from dried moulded paper pulp, the target for this kind of product would be understood by the skilled person to be somebody who wishes to have a one-time use washbowl as opposed to a plastic washbowl, and the primary target for that is going to be hospitals. And that's why His Honour Judge Burr says at 13, in my judgment, it's the context, it is in that context, in the nursing home and hospital, in which a skilled person would understand it. Now, if I could then take you to paragraph 42 of the judgment, at page 111. His Honour Judge Burr is here dealing with a piece of prior art called Zincone Infant Baby Bathtub, and it's a plastic bathtub, and it shows a picture of the baby in it. And His Honour Judge Burr says at 43, I think, and I'll come back to Chaplin in a minute, I think it's further away than Chaplin. Mr. Davis submitted in his written submissions that a bowl for washing is a wash bowl. I disagree. This is a baby bath. It's much larger and it's made of plastic. In my judgment, a skilled person without hindsight provided with this document would read it with interest and would put it to one side. Now, the point that His Honour Judge Burr is making there is, in my submission, the same point we're making here, that merely because something can be used to wash, indeed wash somebody with soap, doesn't make it a wash bowl.
But is that right? Because he deals with the construction issues earlier in the judgment, and there was no reference to the construction of the term wash bowl there. And here, surely the point he's making here is the one which one sees in the penultimate sentence. There's no motivation to make this object out of maceratable wood pulp. That's the whole point about this piece of prior art, is that it's a plastic bathtub. And so the question is, why would you choose to make this thing in maceratable wood pulp? And he says you wouldn't, and therefore there's no obviousness.
But he deals with at 43, the point we're making is that merely because something can be used to wash does not make it a wash bowl. And that's what my learned friend's argument is here. Merely because something could be used to wash, merely because it's a dish, a food container, that you could put soapy water in and use it to wash, does not make it a wash bowl. That's our submission.
And so what do you do with the baby once you've put in it? Do you not wash the baby?
Absolutely, and that's what my learned, that's what His Honour Judge Bursley then was saying. it was submitted that a bowl for washing is a wash bowling bowl. I disagree. So he's taking the same construction point as we take in this case. Perhaps if I could take you back also to Chaplin, which starts at page 35. Paragraph 35, I'm sorry, page 109. Chaplin is entitled Reinforced Moulded Fibre Container, and then he sets it out, and it's a butter dish of a particular shape. And some of the features of the shape could be read on to some of the features of the claims in patent in issue in that case. But paragraph 40 is on a, Judge Burr says, I found it's not obvious on its own merits to make a Chaplin butter dish out of maceratable material, but that doesn't dispose of the issue of obviousness. The question is whether it would be obvious to make a hospital product based on Chaplin as a starting point. And then at 41, he deals with the point. Essentially, one would read it and see nothing of interest in it, except perhaps to make a butter tray of that shape, if that is what they wanted to do. I think the argument that this would make a hospital product obvious is not one which is fair to inventors. So my submission is that what His Honour Judge Burst is doing is the same as I'm inviting your lordships in relationship to find in this case. That it's very easy to say, for example, well, you could use Chaplin to wash something or somebody. However, that does not make it a wash bowl. And that's why we use the analogy. One could use a spanner to hit a nail. It doesn't turn it into a hammer. So in this case, the meaning of the word wash bowl is, we say, absolutely crucial. It does not mean anything that could, and my Lord Justice Arnold made the point, I said anything, it does not mean any bowl that could be used to hold soapy water is a wash bowl. That is making an assumption that the bowl would be considered by a skilled person to be useful as a wash bowl. For example, the sides might be incapable of being gripped and holding a volume of water. It would not be considered by a skilled person to be a wash bowl, any more than the tray-shaped container shown in figure 1 of the patent, of the Japanese application, any more than that is said to be a wash bowl. It's a tray-shaped container.
Can I ask you this question? Was there any evidence from either side before the judge as to what the skilled person would understand by the term wash bowl? Did, for example, Mr. Kelly give a definition in his expert report of what the skilled person would understand a wash bowl to be?
I don't think Mr. Kelly did, but I just checked whether Mr. Waller did though. Mr. Waller's report at tab 24. I'll just need to check. So this is dealing with the shape or configuration patent. And at the...
Sorry, where are you looking?
Paragraph
I'm
26.
page, tab 24, bundle B, page 435.
Paragraph 26.
Paragraph 26.
It'll be detergent resistant. And apart from that, he doesn't say it has any other physical characteristics.
No, but he goes on to deal with the subject at paragraph 34 onwards. And he does deal with it in some detail, starting at 34 and running right through to 49. So, for example, at 35, he talks about the sort of product that has been available before.
So he seems to be taking the view that a washbowl has to be capable of accommodating up to 4 litres.
Yes, a significant quantity of water. That's the point I'm making. It's not impossible to use a small thing to wash. That does not make it a washbowl. To make it to be useful as a washbowl for washing a patient in a hospital, it has to hold a significant amount of water such that you can wash a patient with it. And so he's giving some general indications there, and it was more his field. Dr. Kelly was more the chemist side of things. Mr. Waller was more the moulding expert. But that doesn't mean that the word washbowl has a different meaning. So there was quite a lot of discussion about things which were not washbowls. So, for example, at the top of page 437, paragraph 40, this is a jug and not a washbowl, and so on. And then at 44, he talks about the Vernacare moulded pulp range. So
But I'm a little puzzled here, and forgive me if I've misunderstood, but I thought when I asked you the question earlier whether the claim was limited to products that contained 4 litres, you told me the answer is no.
No.
So to be clear, you say the claim covers something that includes 2 litres?
We didn't test out the lower limits in cross-examination as far as...
What's your submission? Does it cover a washbowl of 2 litre capacity?
There was no evidence in the case, if I can say it this way, as to what the lower limit would be, and one can always play around with lower limits. I don't know whether 2 litres would be considered to be sufficient in a hospital to be considered to be a washbowl. All we have is the evidence that a smaller bowl, not a washbowl, could be used to wash, but that does not mean it is a washbowl. And this is the point that wasn't tested out, we submit, in the evidence. And that's why my learned friend's submission is not based on solid cross-examination of this witness. It's based on an assumption, which was again not tested out in cross-examination, that someone reading either the 2 Japanese patent applications would make something which was of a size that would be considered to be a washbowl. As far as one gets is, could it be as large as a cereal bowl? Yeah. Yes. Yes, so that's that. And I'm reminded that Turner Gardner, which is tab 23, tab 23 in bundle, same bundle, the paragraph we were looking at, talking about bed bathing. Tab 23, that was the tab your ladyship
Yes.
directed me to. Paragraph 18. And this is at 18, at the top of page 424 moulded pulp washbowls, also known to be used, but to a very limited extent. So the argument now being put, as I say, is based on hindsight reasoning that starting with the 2 Japanese patent applications, which appear to be referring to primarily food containers, tray-shaped food containers, and possibly cups, neither of which would be considered to be a washbowl. One then extrapolates that forward to something which may have the volume capacity of a cereal bowl, but no.
Can you help us to this? If you look at the previous page, she starts the discussion of this subject by talking about, in paragraph 14, reusable plastic washbowls.
Yes.
She tells us about those, and so she says in 15 they could be used to wash anything from feet to bottoms to faces, and so on. And she talks about them being stacked in washing machines,
Yes.
and so on. So, what size limitation do you say is implicit in her evidence that?
The answer is I don't. There's nothing expressly said, but this is a hospital environment. We didn't have evidence as to what washing machines were used in hospitals. We did have some evidence that autoclaves and things or similar were used to sterilise. But
would you accept that a plastic wash bowl of a size sufficient to wash a patient's face would nevertheless be a wash bowl?
I don't. My submission would be that the people skilled in the art would not have called that a wash bowl. They would have called it
So
a
the
general.
Turner Gardner is wrong to describe these products as wash bowls. Is that your submission?
She was a fact witness. She explained that they could be used in that limited way. The product was not, my instructions are, and I think there's no evidence, marketed as a wash bowl. It was marketed as a bowl or general purpose bowl. The point is, though, that, and therefore the lower limits of it were not tested out by my learned friend in cross-examination. What my learned friend is doing is taking these leaps. Japanese patent application, food might be a bowl might be cereal sized. No details as to how it might be held, whether it could be usefully used to transport water from a sink across a hospital ward or something to a patient. And then to say, because a bowl of that capacity could be used to wash, it would be considered by a skilled person to be a wash bowl.
And then you're back to your spanner and hammer.
Yes.
But is the difference with the hammer not that that's a term which implies a certain amount of specificity about the physical characteristics? So it's got a handle, it's got a weight at one end. It's not just a length of metal rod, for example.
Yes.
You wouldn't call that a hammer.
Yes.
Whereas, perhaps unfortunately for your clients, the word bowl doesn't bring with it any connotations of particular physical characteristics, even with the qualifier wash.
It does, with respect, because in order to be a wash bowl, and there was some discussion about this in the context of the configuration or shape pattern, one's envisaging a patient in a bed with the nurse having to carry a volume of water to the patient. That would be what a nurse would consider to be a wash bowl. A sufficient volume of water to wash the patient. And I accept the lower limit of that was not tested out, but it's not for me, we say, to test that out. My learned friend wants to make an obvious case. In this case, it was for him to test that out.
I'm still struggling to understand the basis for this argument in the words of the claim. I mean, if we had wash bowl for hospital use, or some wording like that in the claim, then I could quite understand the case. But why does the claim not cover wash bowls for washing cars?
Well,
Or washing anything in?
it's got to be maceratable. If one could go back to the claim,
To be sure.
it's got to be one's got to read, for the sake of the office, one has to read the patent in the context of how it is written. And bearing in mind, this was a case preceding the IPEC with specifically pleaded cases and tables of claims. It does not mean, if my learned friend wanted to run this argument, it does not mean, and this is why I say my submission is right, it does not mean anything that can hold soapy water.
Right, so your submission is that we construe the word wash bowl as a wash bowl for hospital use.
Yeah, or similar, yes, absolutely. It's got to be maceratable, and it's got to be read in the context of the patent, which describes the problem to be solved.
I think
I think you're getting mixed up with the other patent.
So it doesn't say maceratable in the claim. I apologise. But it does say it in the description, and the skilled person would appreciate that from the construction that is covered by the claim.
now where have we got to?
So it is correct to say that there were certain limits as to what a skilled person would understand by the claim that were not tested out in cross-examination by my learned friend. What my learned friend is doing is, now that the evidence is, because my learned friend's primary case all along was that the skilled person would know that adding a fluorocarbon would induce detergent resistance, essentially because it would also introduce oil resistance. But that case was rejected on the evidence and on the basis of the skilled person. So what my learned friend is then forced back to doing is to explore a case which wasn't properly explored, we say, in cross-examination. And what he's done is he's picked up a passage from Mr. Gardner, who was just referring to the volume of water in the LA bowl, and building his obviousness case on that, which we say is not fair to inventors. The patent is for a wash bowl, detergent resistant, and we say it would mean to the skilled person something which was suitable for washing a patient in a bed. It needs to have lips and means to carry from the... It's got to be suitable so that a nurse can say, I can see I could carry a volume of water from a sink to a patient, wash the patient, take the water back. That's what we say a skilled person would understand by this patent, just as His Honour Judge Burst took a similar view in relation to the parallel patent concerning configuration. So for that reason, we do say this is a case of hindsight reasoning. The extrapolation being, if you know your target is to make a wash bowl, as I've defined it, if your target is that, you then make the following extrapolation. Shimooka talks about food containers, tray-shaped containers and cup-shaped containers. Dr. Kelly said he envisaged something like a bento box and a cup-shaped container one might consider to be maybe something for carrying little pieces of food. In it, maybe some condiments or something like that. That's a cup-shaped container. He then picks up a reference to possible wider uses. But the patent is talking about containers which are deeper than pressed containers. It's not talking about making something which would be a wash bowl. It's making something which one might make as a food container, particularly a tray-shaped food container. And
You might say, I suppose, to somebody writing in Japan, the difference between a cup and a bowl is not quite so distinct as it is to someone writing in England. Cups and bowls are used interchangeably. They're all small.
They're all small, but nobody would suggest a cup was a washbowl, and it talks about cup containers, the cup-shaped containers. The translation is not perfect, but then Lord Justice Floyd and Lord Justice Arnold knows sometimes the original Japanese is not perfect either, but it's what we have to work with. And one can see it's directed, we say, to that sort of thing. And therefore, and I've said it before, but what my learned friend is doing is using this hindsight reasoning to say, well, the target is something that that a skilled reader would consider to be a washbowl. Well, he has to accept that a cup isn't a washbowl. He accepts, I think, that the tray shown in figure 1 is not a washbowl. But he says, don't worry about that, because what you can do is hypothesize a cereal bowl, or at least something of cereal bowl size. But just because it's cereal bowl size doesn't mean that a skilled person would say that's a washbowl. They would say, well, that's a cereal bowl. Which is why I say the analogy of hammer and spanner is apposite in this case. He is saying because you could use a cup, a tray, a cereal bowl to wash, ergo it's a wash bowl. And we say that's, with respect to wrong analysis, and the judge adopted the right analysis, and his analysis is in line with the analysis, we say, that His Honour Judge Mercy then was adopted in the previous case. A baby bath is not a wash bowl, it's a baby bath. A butter dish, not a wash bowl, it's a butter dish.
In paragraph 29 of your skeleton, you say it involves a process of hindsight reasoning to say that it would be obvious from the disclosure in Shimooka to make something at least the size and shape of a cereal bowl. That sentence did rather suggest to me that you accepted that the cereal bowl size was good enough.
No, well, I went on. That was what I was putting. What their argument is. That's their argument. And 30, though, is our point. Is even if it could be made, and my learned friends are saying that's putting intention into it. It's not putting intention into it. It's doing exactly the opposite. We say the thing is, you don't know you're trying to make something detergent resistant. What do you think you're trying to make is some form of tray-shaped or cup-shaped food container. So the hindsight reasoning comes in because built into my learned friend's argument is, well, even though I don't know it, I'm going to want to make something which is and would be considered to be a wash bowl, rather than I want to make something which could be used for its not intended purpose as a wash bowl, but that doesn't turn it into a wash bowl. It stays all along, whatever it is, a tray, a bento box, a cup, whatever. I've probably exhausted all the submissions I can make on this point, my lords and my lady. But of course, if there are any other questions you have, please do ask them. And may I just take some instructions to check I've covered all the points that I need to. No further submissions.
You haven't said anything about claim 3.
Oh, I do apologise. Yes, I haven't said anything about. I became so carried away by claim 1. I haven't said anything about claim 9. Now I deal with claim 9. I do apologise.
Sorry, claim 9.
Claim
Grounds 3.
Yes, I do apologise. Yes.
It's at paragraph 32.
Paragraph 32. So I've set out claim 9 there, and of course, in most patent cases, when claim 1 goes, it goes because one knows what one is making. In this case, even on my learned friend's case, claim 1 only goes because the skilled person makes something which they don't even know will be detergent resistant. So that's what makes it unusual. We don't start from the starting point one often deals with subsidiary claims, that claim 1 is obvious in a, and this is assuming against me, that claim 1 is obvious. It's not obvious in any typical sense that the very thing you want to make is detergent resistant washbowl. It's only obvious in a technical sense that my learned friend is urging upon you. Now, Shimooka doesn't disclose any details of the relative proportions of the binding agents. And as we note at paragraph 34 of our skeleton, Dr. Kelly's evidence was that the range claimed was not part of the skilled person's common general knowledge. And that wasn't surprising, because his view, which the judge accepted, was that the use of a fluorocarbon in a moulded paper pulp article was not common general knowledge. Indeed, it wasn't known at all. So the only starting point one has for the obviousness attack is Shimooka. Now, what my learned friend does is, with Professor Hearn's evidence, is to take that out of context. The point is that Professor Hearn's underlying proposition was that the use of a fluorochemical sizing agent in paper products was something that was obvious and known. But that was rejected by the judge in paragraph 94 of the judgment. So the part of Professor Hearn's evidence, which my learned friend relies upon, which we set out in paragraph 35 of the skeleton, has to be read in that context, in the context of Professor Hearn saying, well, I believe these things are known. But in the case of Shimooka and the common general knowledge as found by the judge, which is unknown to use fluorochemicals at all in moulded paper products, and certainly unknown that they would impart oil or grease resistance, or...
Yes, but by this stage of the argument, one's assuming, contrary to your previous submissions, that claim 1 is obvious. So what we know is that we are implementing Shimooka to make something which will fall within the description of washbowl. And Shimooka doesn't tell you how much fluorocarbon to put in. And so the argument is that since the skilled person doesn't know from their common general knowledge, because of the definition of skilled person, it follows they have to take specialist advice. And the judge held that the skilled person would seek specialist advice where necessary.
Yes. But what this... That's absolutely right. But the question was, for what purpose would the skilled person be adding it? It would not be added to impart detergent resistance. It would be added to impart oil grease resistance. And Professor Hearn's evidence, we submit, was directed to the skilled person adding it for the purpose intended in the patent, not for the purpose intended in Shimooka. So our submission is that he, given that his evidence as to the common general knowledge and the nature of the skilled person was rejected, his evidence regarding claim 9 automatically fell because he wasn't asking himself the right question, which was, what would somebody implementing Shimooka, oil and grease resistance, add by way of fluorocarbon?
Do you dispute Mr. Olkin's construction of the claim? Viz, that because it's talking about the liquid quantity, it can cover any amount of active ingredient from negligible to loads. And in fact, you don't know.
I accept that the amount is not specified in the claim. I accept that.
So the claim is all about the carrier. And your argument is that it wouldn't be obvious to put that much carrier in with your fluorocarbon.
Yes, that's it. The question really is, why would you be, what quantity, how would you be adding it if you were following one of the two?
Would it be different? Would it be different for that? Surely what gives it the detergent resistance or the oil and grease resistance is the amount of fluorocarbon.
The exact it was accepted. There was an insufficiency attack which was not pursued in the event. The exact amount that would need to be added to obtain oil and grease resistance was not compared with the amount that would need to be added desirably for detergent resistance.
When you say the amount, you mean the amount of carrier?
The amount of carrier, yes. That wasn't discussed at that level of detail because, of course, Professor Hearn's proposition was that you'd be adding it in order to impart detergent resistance because the skilled person would know that you were trying to achieve detergent resistance.
But can I come back to the question of claim construction? Because you've accepted that it's not limited to any particular amount of active ingredient. Now, if it's not limited to any particular amount of active ingredient, this claim is non-limiting. I mean, yes, you have to have a certain amount of carrier, but the amount of carrier is irrelevant. What matters is how much of the active ingredient, and you've accepted there's no limitation.
I accept that. The problem was the judge was left with an area which he got evidence from Dr. Kelly, where Dr. Kelly said, I don't think it's obvious. And he had evidence from Professor Hearn, which was directed to a different issue. What needs to be considered, we say, in respect of Claim 9, is assume against me that the skilled person is driven to make an article which is a food container, which nevertheless could be used to wash. If we're wrong on that construction and it then is deemed, in a sense, to be a washbowl, you're still, as a skilled person, trying to impart oil and grease resistance, not detergent resistance. And the judge was left with a gap, we say, in the evidence. We had Dr. Kelly saying one thing and Professor Hearn heading off in a different direction because his view was that it was obvious to add for detergent resistance.
Anything else on Claim 9?
No, that really does complete my submissions. I'm sorry for jumping the gun there.
No, thank you very much. Not at all. Thank you very much. Reply after the short adjournment. Presumably you're going to want a few minutes, are you? Or
I think I can probably be done in 2 or 3. So
well, in that case, we'd be very happy to hear you now.
I'm grateful.
Unless that's going to cause massive inconvenience to anyone in the court. No.
First, my learned friend addressed you on the proper reading of Shimooka. And effectively his argument is that Shimooka is only proposing a variety of shapes that are just a bit deeper than a tray, because that's an improvement on a tray. So that's all the skilled person would understand Shimooka to be proposing. And in my submission, there's no reason to read Shimooka in such a limited way. The document talks about a wide variety of shapes. To suggest that this was implicitly limited to a variety of shallow shapes is not consistent with that language. But even if you do read it with that way, in my submission, plainly the skilled person's imagination would not be so limited. When the skilled person is told to contemplate a variety of shapes, the unchallenged evidence of Vernacare's own expert is that included a variety of bowls of a variety of different shapes and sizes. And plainly, that disclosure of Shimooka would trigger that common general knowledge on the part of the reader, regardless of what they understood Shimooka to have in mind. So in my submission, that really doesn't help my learned friend. There was debate about the LA washbowl, and in my submission it really came down to 2 issues. First, was it really detergent resistance? And second, was it of a size and shape that might be characterised as a washbowl? And on the first point, it was common ground that the term washbowl implied the ability to contain a volume of soapy water. But my understanding of Miss Turner-Gardner's evidence was, as long as you use this wash bowl quickly, it did that. So she wasn't, I think my learned friend said, as soon as you put soap in, it disintegrated in moments. That was not her evidence. Her evidence was it went soggy quickly, particularly if you put soap in, but she still described it being used to wash the hands and face of a patient. So I'd always understood her evidence to be that this was sufficiently detergent resistant to be of utility as a wash bowl. So I've certainly never accepted that that was not a wash bowl within the meaning of the claims. But even leaving that aside, on the question of size and shape, it was plainly of a size and shape that Miss Turner-Gardner considered was apt to be described as a wash bowl. And my learned friend, I think, for all of the many things he said about what a wash bowl might and might not be, one clear thing he said is that it's an article that in a hospital context would be considered by somebody in a hospital as a wash bowl. And there you have contemporaneous evidence of a user of these articles describing a bowl of that size and shape as a wash bowl. And I say that's a very neat way of meeting his rule of thumb for what the term means. My learned friend, at last, in reply in the Court of Appeal, started to advance what he said were implicit functional limitations on the term wash bowl. So that was not done at trial. It's not done in his skeleton argument, despite my urging. And now we finally hear that perhaps it involves flanges to facilitate lifting, minimum levels of volume, and so on. And in my submission, it's not for him to start advancing that type of construction point now. But in any event, they're hopeless as a matter of construction of the document. If my learned friend's clients had wanted to place functional limitations upon the meaning of the term of that kind, they could have done so explicitly. That's what the other patent is about, is defining a particular shape for a wash bowl that makes it easy to carry. So for my learned friend to now say, you can simply construe the term as importing that type of functional limitation, we say is not tenable. And again, we go back to the rule of thumb. It's an article that would be regarded as a wash bowl by its user. We have the evidence on that. But even if there were some lower limit on volume, and even if you were able to accept that that was larger than a cereal bowl, and I say there's simply no basis to do that, I do say the notion that it would be an independent invention, a patentable invention over Shimooka, to make a bowl that was capable of holding more than one portion of food, a salad bowl, for example. The idea that that in and of itself would be a patentable contribution to the art over Shimooka is simply not tenable. Bowls of various shapes and sizes are within the common general knowledge of the CGK, and to apply that common general knowledge in the implementation of Shimooka is simply not inventive. So that was all I wanted to say in reply.
Thank you very much indeed. Well, thank you all very much indeed for your submissions, which have been dealt with concisely, but no less effectively for that. You won't be surprised to hear that we will reserve our judgments. They'll be handed or sent out in draft in the normal way. May I remind you of the very strict embargo that now appears on the top of the draft. And we must be sent proper lists of the people that are going to have sight of the draft. The draft, as you're aware, is for typographical, minor factual errors. It's an opportunity to re-argue the case. We'd hope that you would be able to agree any outstanding matters in writing between yourselves. If you've got any difficulties, we'll resolve them as between ourselves in writing. Thank you all very much indeed.
All right.